orientation. We shall overcome. They ignored the court's holding that sexual orientation is a suspect classification.
We shall overcome.
They ignored the holding that there's no compelling state interest in distinguishing between same-sex couples and opposite-sex couples for purposes of eligibility to marry.
We shall overcome.
In doing so, we argue to the court that the electors have ignored the Supreme Court's role in interpreting equal protection and other rights under the California Constitution and attempted to rewrite the court's decision on constitutional controversies that were previously settled.
We shall overcome.
Now, this week, finally, we are so happy to say, the Supreme Court of California sent me this. They've accepted our case challenging us in our briefs to answer 3 questions, and we are so happy to have the opportunity to answer those 3 questions in the briefs that we will file next month. But I'm going to give you a little preview because I can answer them right now, and I'm going to answer them for you. So I hope the yes or nay people are listening, because get ready for this to come barreling down the pike. Issues to be briefed and argued in these matters are as follows. First, is Proposition 8 invalid because it constitutes a revision of, rather than an amendment to, the California Constitution? And of course our answer is yes! And the reason is because no substantial change can be made in our California Constitution through the initiative process. If there's a revision to be made, they must go to the legislature, they must seek a 2/3 vote of the legislature, then a ratification by the people, or have an authorized state constitutional convention, and then ratified by the people. They did neither because they knew they wouldn't be successful there. So they could call it a constitutional amendment to their heart's content. But naming it so doesn't make it so. It's a disguised constitutional revision, and we know it. We have to follow the rules, and so do they. And they failed to do so. Second question, does Proposition 8 violate the separation of powers doctrine under the California Constitution? Our answer is yes! Why? And by the way, I'm happy to say we raised that issue in the petition which we just filed with the Supreme Court. We're very happy that they decided that that is an important question and would like to have it answered. And it does violate the separation of powers because it is a long-established precedent in California and case that we have 3 branches: legislative, executive, and judicial branch. Each has its own power and may not exercise the power of the other. Once there is a settled, finally adjudicated Supreme Court decision, it may not be eliminated, it may not be abrogated, it may not be undermined by the legislature or by the people through revision whose power is coexistent with the legislature. So it violates the separation of powers, and we cannot and will not allow our Supreme Court to be undermined. And finally, last question, real short. They ask ask, if Proposition 8 is not unconstitutional, what is its effect, if any, on the marriages of same-sex couples performed before the adoption of Proposition 8? Well, the answer, we believe, is clearly they are valid under any set of circumstances. They were married between May and November 4th, when the Supreme Court said it would be unconstitutional to deny them a license. They cannot, it would be a violation of due process to nullify their fundamental right to marry. Their marriages are valid.